once again excited to have the folks from the Rocky Mountain ADA Center, and Maggie Sims will be presenting to us today on the subject of employment accommodation. How does the ADA affect us when we have employees? And so we're very excited to have this subject, because I know a lot of people have questions about this. And how do I comply? How do I help my employees succeed in all situations, but particularly if they may have a disability? So Maggie, I'm going to go ahead and throw the ball over to you. If you can start working on that. Hopefully that will come up easily this time. Okay, I can see your screen coming in. Maggie is the project director at the Rocky Mountain ADA Center. It is a project of Meeting the Challenge is the name of the overall company, and they work under a grant from the Department of Justice. Is that correct, Maggie?
Actually, we work under a grant from the U.S. Department of Education. We work closely with the Department of Justice. They're one of the enforcing agencies, and we'll talk a little bit about them today. But mostly we'll talk about the EEOC, which is the enforcing agency for Title I. So thank you so much for having us again. And we will be talking about Title I, which is employment under the Americans with Disabilities Act. I've got on our front page, we've got some information about how to contact us, who we work with. We do serve 6 states, of which Utah is one of them. And so we're thrilled to be working with you today. We have to give a little disclaimer. Any of the information, the materials, the technical assistance that we provide, it's called informal guidance, and so it's not a determination of any legal rights or responsibilities. So it's not binding, but we do provide guidance on what the law says. And as Jason mentioned, we are authorized under the grant number, and you can see that, to provide the information, materials, and technical assistance to individuals and entities that are covered by the ADA. So we're an unbiased information center. And what we do, we provide that technical assistance specifically on the Americans with Disabilities Act. And so you can call us, you can email us, you can text us with questions that you might have about the Americans with Disabilities Act. And you probably have a lot of them, and if you don't yet, you will eventually, I'm sure. We do a lot of referrals and networking with other disability organizations, and so if we can't answer a question, we may refer you to someone who can. We do lots of research on disability issues, trainings, and lots of material dissemination. So when you have questions, give us a call again, and here's our 800 number. Or again, you can also contact us on our website. And I wanted to mention too that there are actually 10 regional centers across the country, and so that 800 number will route you automatically to your center. And you can see in the picture here the different regions that we have. We also have a national website, which is adata.org, and as fellow workers on the ADA, we have lots of different materials and information at the different ADA centers, and so we try to get that out to all of our groups and all of our regions. So do check that out when you get a chance. So let's talk about ADA basics, and we'll start out with who has responsibilities under the ADA. And to begin with, all private employers who have 15 or more employees are covered under Title I of the ADA. This can be changed a little bit because of state requirements. For example, in the state of Colorado, any employer with any amount of employees does have responsibilities to not discriminate against a person with disabilities. So, but the ADA would cover only 15 or more. The second that you see is all state and local government entities, which is what you folks would be state and local government agencies. And so it doesn't matter if it's a smaller city, state, county. If you have employees, you're covered under Title I. And just as so for your awareness, employment agencies are covered, labor unions are covered, joint labor and management committees. Title II entities also have an obligation to ensure that any of the contractors that they work with also do not discriminate. So in other words, if you were to use an employment agency to find employees, you want to be sure that that agency is also not discriminating, because it would be your responsibility to ensure that they are also not being discriminatory. So who is protected under the ADA? The ADA doesn't have a list of disabilities, so to speak, and so it's very broad in what it would cover. So it would go by the definition that it protects the rights of people who have a physical or a mental impairment that is substantially limiting their ability to perform one or more major life activity. We'll talk about major life activities shortly, but just so you know too, the ADA does not apply to people whose impairment is unsubstantial. And what that means is it's an impairment that doesn't rise to that level of a disability. As an example, somebody who is nearsighted or someone who has maybe a mild allergy, these would not be considered substantially limiting, although there can be opportunities and times when they could be considered a disability if it becomes substantially limiting in their life. The ADA still applies to disabilities that can be mitigated. What that means is, as an example, if someone has diabetes, and it's substantially limiting, but they're able to take medications that mitigate the issues that it causes, they would still be covered by the ADA, and so they may still need to be considered for an accommodation or other requests that they might have. Some other mitigating circumstances that you could use as an example, a person who uses leg braces to walk, they still are limited in a major life activity of walking, but because it's mitigated doesn't mean they're not still covered. So you want to be sure that you keep that in mind. Also, hidden disabilities. There are many hidden disabilities, such as psychiatric disabilities, diabetes, seizure disorders. These are all covered, so whether or not we can visually see a disability, they will be covered if they substantially limit a major life activity. The other two definitions to what is a person with a disability is that a person who has a record of a substantial impairment, they're also covered under the ADA. So an example of that could be someone who maybe had cancer at one time that did substantially limit them, and that is not the case now, but they have that record. And sometimes an employer may fear hiring someone who has that record, and this would be considered discriminatory. Those who are regarded as having such an impairment, and again using the same example of a person maybe who has cancer, it may not be substantially limiting for them, but if the employer regards them as having that impairment, then they have protections under the ADA. So we talked about major life activities. And what is a major life activity? Pretty much what you would expect. It's caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, thinking, walking, standing, lifting, bending, communicating, breathing, reading, working is considered a major life activity. Also, the operation of major bodily functions are covered under the ADA. as an example, reproduction, our immune system, digestion, circulation, all of these bodily functions are covered under the ADA. Keep in mind that this is a non-exhaustive list, and so it can, it's very broad. It was, the EEOC wanted this to be looked at from a very broad stance, so you want to keep that in mind. In addition to the definition, a qualified individual for employment also satisfies the skill, the experience, the education, and all the other job-related requirements that is required of a specific job position. So just because a person has a disability doesn't necessarily mean that they are qualified to perform a particular job. They need to be able to perform the essential functions of the position, and that is with or without a reasonable accommodation. And we'll talk about reasonable accommodation. Generally speaking, an employer is not required to hire or retain an individual who is not qualified to perform that job. So basically, again, you can hire, fire, promote the most qualified, deserving individuals. You just don't want to discriminate because an individual has a disability. So a general employment rule is that it is unlawful to discriminate against a qualified individual with a disability with regard to basically all parts of the job process. That would be the application process, in the hiring, in promotion, discharge, the compensation, any other benefits of the job, training. All of these areas would come under the ADA to ensure that an individual with a disability can perform his or her job functions. The other important aspect of this is that the individual should be able to perform the essential functions of the position, and we can't discriminate against that. And there are different ways that we can discriminate, so let's talk a little bit about essential functions. And when we talk about essential functions, what are we talking about? Seems pretty obvious. It's job duties that are fundamental to that position. It's things that the person holding that job must absolutely be able to do to have the job performed. There's some factors for determining what or how to determine what are the essential functions of a position. So you would look at the position exists to perform the essential functions. What about the number of other employees that are available to perform the same job duties? This can determine if this is an essential job function. You can also consider expertise or the skills that are required to perform this particular position. When you're looking at essential functions, it doesn't include marginal or peripheral functions. And so you want to determine as the employer what are the essential functions, and then what are functions, you know, that would just be nice for the individual to be able to perform, but maybe others can do it. So there is a difference there. And also the essential functions, it specifies what needs to be done and not necessarily how. What that means is, you know, it may not be done in a traditional way that we are accustomed to. We may have a job function that's essential, but they may do it a different way thanks to a reasonable accommodation. So you want to look at what needs to get done and not necessarily how they're going to get it done. And this would also include with or without an accommodation. So keep in mind that we can ask an individual, can you perform the essential functions of this position with or without an accommodation? And if they can answer yes, then they may be qualified for that position. Let's talk about reasonable accommodations and what they are. Pretty obviously, they're modifications or adjustments to a job, to the employment practice or the work environment that makes it possible for an individual with a disability to enjoy an equal employment opportunity. So we modify, we adjust. It might be, it can be a lot of different ways that we do that. It's any change basically in the work environment for an individual with a disability, so they can enjoy that equal employment opportunity. And the definition of that would just be the opportunity to attain the same level of performance or to enjoy the equal benefits and privileges of employment. So sometimes that's what's necessary, and as the employer, we are required to consider that. So let's look at some accommodation basics. There's really no formal way for a person to request a reasonable accommodation. There's no form that you're required to provide or have available. You certainly can do that if you want to. Sometimes it makes it a little bit easier. It also doesn't have to be a written request. So there's different ways that an individual can actually let someone know that they have a need for an accommodation. They don't have to basically say, I need a reasonable accommodation. They may say something along the lines of, I need 6 weeks off to get treatment for a back problem. This could be a request for a reasonable accommodation, and so you want to consider this and take it seriously. Maybe someone says, I'm having trouble getting to work because of the medical treatment that I'm undergoing. This can be a request for a reasonable accommodation. So you want to be aware, again, that it's not always formally done, but once you hear these requests, you are responsible. It doesn't necessarily need to be the best accommodation in every situation, but it does need to be effective. The employer makes the final determination of what is reasonable to provide. Just keep in mind that it does need to be effective. And if the employee comes back and says, this is not doing what I need it to do, then you need to have a dialogue. You need to have some more conversation and see what else might be available. You don't have to provide any kind of personal devices, and personal devices would include items such as eyeglasses, wheelchairs, canes, hearing aids, things of that nature. That is not the employer's responsibility. Keep in mind that these accommodations only need to reduce employment-related barriers. So it is something that they will need to be able to perform their job position. Of course, an employer is not prevented from providing extra accommodations. They can always do more than what's required, and many times do. So the ADA would not prohibit that. Also, the accommodation obligation is an ongoing responsibility, and so communication needs to stay open between the employer and the employee. Is the accommodation working appropriately? Do we need to make some adjustments? And it may be, too, that one accommodation may not provide the effect that was hoped for, and so you may need to look at a different type of accommodation. When a person requests an accommodation, you need to take it seriously, and it needs to be provided as expeditiously as possible. The ADA doesn't give a specific amount of time that it has to be provided. For example, if there's nothing that says you have to provide an accommodation in 7 days or in 30 days, but it needs to be provided as quickly as it can possibly be done. And of course, different situations, different requests are going to determine how long it might take. Some accommodations may be able to be taken care of within a day or a week, while others may take some longer research and gathering of information to see if it's reasonable and then to provide it. The important thing is that when the request is made, you want to take it seriously, you want to document it, and you want to begin looking into it as quickly as possible. And as I mentioned a minute ago, documentation is really, really important for everyone. So document when the request was made. document what actions are being taken and who is involved in determining this. You want dates and any adjustments that might need to be made as you go along. So this is pretty important to do. And confidentiality is always important. Things to keep in mind: you need to keep disability files separate separate and confidential from their regular employee file, personnel file. The information should only be made available to those who have a direct interest in that. Only the staff that needs to know this medical information, which usually means supervisors, managers, those who might work directly with the individual. Sometimes the situation when coworkers notice a change, they may perceive this as kind of being, preferential treatment. What does an employer have to do? Can they tell the coworkers that the person has a disability? Well, the answer to that is no. That is not information you want to provide to coworkers. If a person is asking, well, why do they have this? Or, again, seemingly feeling like the other is getting preferential treatment, you want to have a statement that you can provide, something along the lines of saying, as an employer, we are acting for legitimate business reasons for this individual, or something along the lines of we're complying with federal law, and keep it at that. They don't have to know any more information than that. So when are accommodations required? It's basically all aspects of employment to a known disability that a person has made the information known because they need the accommodation. So in other words, an employer doesn't have to provide an accommodation to a disability he doesn't know about. So again, it's the requester's responsibility to let the employer know. But it applies to all aspects of employment. So when you're putting advertisements out for a job position, this is covered. You may need to provide alternate formats. The applications are covered. If you provide applications online, you need to remember that these need to be accessible for an individual with a disability. Persons who may have visual loss may need some kind of an accommodation, some kind of an alternate format. So you need to either have an alternative to the online applications. That would be acceptable as well. But keep in mind, your website, anything that you have online, is also a service of the Title II agency and needs to be accessible. The interview process needs to be accessible. For example, if you had an individual who is deaf and they're applying for a job position, they may let you know that for the interview they need an accommodation, which can be a variety of things, possibly a sign language interpreter. But the obligation is there for the employer to provide this accommodation unless it's an undue hardship. And we'll talk about that soon. And then, of course, the employment process. Once the person is employed, then of course all portions of the employment benefits, such as training, travel, these all do fall under the ADA and the obligation to provide an accommodation.
Hey Maggie, could I ask a question here?
Sure.
We had somebody submit a question here. Shauna asked, if your process is to have the employee fill out a form and get medical information from the doctor, and you are waiting for the information back from the employee, and they take a long time or they never get the form back to you, what obligations does the employer have at that point?
And that's a great question. The employer, and we'll talk a little bit more about this, but the employer, if it's not an obvious disability and they've requested to have medical documentation, the employee has that responsibility. That is his obligation to provide that. And in the meantime, you can provide a temporary accommodation depending on the situation, but ultimately, without that documentation for a disability that's not visible, the employer doesn't have an obligation to do any more until they have that documentation.
So you'd probably want to follow that up with, you know, just to cover that, probably some sort of a note to file or documentation that, you know, we requested this from the employee and they didn't produce the material.
Absolutely, the documentation is so important. So I would say, you know, put a note in there that we contacted Joe Smith about this on April the 5th and are waiting further documentation. Everything you do to show that you have really worked with the individual and really tried to get this information is going to work in your favor. So absolutely, documentation is, you should always do that.
Thank you.
Mm-hmm. And we'll talk some more about that. So, and we'll have some question and answer time. So when must a person disclose that they have a disability? Well, an individual doesn't ever have to disclose unless they need an accommodation. And so a person who is applying for a job position, they don't have an obligation to even let the employer know that they have a disability unless they're going to need an accommodation. So what happens if the individual initially decides not to disclose, but then discovers later that they will need an accommodation? Does this mean the person has been dishonest on their application? It doesn't, because an individual with a disability may request a reasonable accommodation at any time during the application process or during employment. The ADA doesn't prevent an employee from requesting the reasonable accommodation later on in the process, just because they didn't ask for it at the beginning of the process, at the application. This is to protect that individual. Again, this information is not allowed to be shared yet with the employee to protect that individual. Once an individual does start to work, and let's say that the performance is suffering because they have a disability but they haven't requested an accommodation, surely it would be in the employee's best interest that when he realizes that there's some problems and that he needs an accommodation, should let the employer know as soon as possible. The EEOC has basically divided the employment process into 3 stages. And this is important to know as far as what kinds of questions that can be asked of the potential employee as you go along. And the amount of disability-related information that the employer can request depends on what stage of the employment process. So let's look at those 3 stages. The first one is called the pre-employment stage. So this would obviously be applicants, interviewees. At this stage, the employer cannot ask the applicant about the existence, the nature, or severity of a disability. This should be considered to be confidential at this point. The applicant may be asked about the ability to perform the specific job functions. That would be appropriate. But no medical inquiries or medical exams until after a job offer has been made. The job offer may be conditioned on results of the medical exams or inquiries, but only if it's required for all entering employees in similar job positions. So, for example, say a person has a visible disability. You don't want to have this individual take a medical exam or have some inquiries that you wouldn't ask of everyone in this particular job position. Medical exams of employees must be job-related and consistent with the employer's business needs. So again, this goes back to, because we think someone has a disability, we're not going to subject them to an exam that we wouldn't ask everyone in that particular job position to go through. You also cannot ask if the person has a mental impairment. You cannot ask if they've received workers' compensation or if they've ever been addicted to illegal drugs at this stage of employment. Although the employer can't ask disability-related questions or require medical examinations at the pre-offer stage, they can do a variety of things to evaluate whether the applicant is qualified for the job. Some of these include, you can ask about the applicant's ability to perform specific job functions. You can ask the applicant non-medical qualifications and skills, just like you would anyone. You can ask the applicant to describe or demonstrate how they might perform a specific job task. The second stage is a conditional job offer. And so what constitutes a valid job offer? The employer has evaluated all relevant non-medical information that it can reasonably obtain at this point and analyzed it and has a good idea that the individual can provide can perform the essential functions of this job. At this stage, employers can ask disability-related questions. They can require medical exams, again, as long as this is done for all entering employees in a particular job category. What happens? Can an employer rescind a job offer without violating the ADA? After the individual has gone through medical exams, disability-related questions, the employer can rescind a job offer, but it must be able to demonstrate that the reason for the rejection is job-related and consistent with business necessity and is not related to the person's disability. And then, of course, there's the employed stage. Once they're on the job, the employer may only seek disability-related information if there's a reasonable basis for the employer to think that the employee is unqualified to do the job, needs a reasonable accommodation, or poses a direct threat to the health or safety of the employee of others. What medical information can an employer ask for once an accommodation request has been made? When the disability or the need for the accommodation is not obvious, the employer can ask for reasonable medical documentation. And this will be to establish that the employee has an ADA disability, that shows that the employee needs the requested accommodation, and then also to help determine effective accommodation options. Many times there's more than one accommodation, and of course different workplaces, some things will work, some things won't work, and so it's an ongoing responsibility to talk with the employee and the employer to determine what is going to be effective and what is reasonable for us as the employer to provide. When asking for documentation, of course, the information is limited as to what the employer can request, but basically they just need to get documentation that the employee has a disability and that the disability requires an accommodation. So in most situations, an employer can't request a person's complete medical records. This is likely to contain information that is not relevant to this particular disability at hand. So keep in mind that the information, even at this point, should be completely related to the disability at hand. Now, it's possible that an individual may have more than one disability and could need more than one accommodation. So but the employer can only request documentation for the disability that needs accommodating. Not all disabilities will need an accommodation. So when we're talking about documentation, what do we mean? It should come from an appropriate health care or rehab professional. The appropriate professional in each situation will depend on the disability, the type of functional limitation that it imposes. So it can vary from person to person, situation to situation, disability to disability. So who can provide the appropriate, who are the appropriate professionals to include, but not limited to? These can be doctors, which of course can be psychiatrists, psychologists. It could be nurses, physical therapists, occupational therapists, speech therapists, vocal rehab specialists, licensed mental health professionals. So you can see there's not a limit as to who would be considered a professional. Different disabilities may have different professionals that work with them. So what are some examples of some accommodations? Let's look at some, and there's, of course, the number is endless. There could be lots of different things depending on the disability and the person and the job that they're doing. Some examples that have been determined by the Equal Employment Opportunity Commission to be usually reasonable will be services such as readers for somebody who maybe has a visual loss, or somebody with a learning disability, note takers, braille, large print, for individuals who may have hearing loss, sign language interpreters may be reasonable, CART, which is real-time captioning, and then there's captioning for videos, meetings, video relay interpreting, and video relay services. These are wonderful technological advances that allow individuals who are deaf, hard of hearing, to be able to work in the workplace and do just about anything that anyone can. Video phones. Some modified policies may also be required. This can be a little more difficult sometimes to determine. But you want to look at your policies. When you have policies, say for example you have a 100% restriction-free policy or no-fault attendance policy, these can be problematic under the ADA if they're strictly adhered to. If a person needs to request a modified policy as a reasonable accommodation, it needs to be considered just as you would consider any other type of an accommodation. Allowing service animals is another form of reasonable accommodation, and we're going to talk about that in a little more detail. But that is a modification of a policy. Reassignment to another position can be a reasonable accommodation. This would be only required if the person is able to do that job position. You don't have to create a position if there's not one available. And of course, as we mentioned, an employer can always do more than what the ADA says. But these, technically, that's what the law says. Flexible schedules can be a form of reasonable accommodation. Job restructuring, modifying equipment, making the existing facilities accessible, and working from home. These are all different forms of reasonable accommodation. They won't all apply in every situation and for every employer or employee, but these are things that need to be considered when requested. The EEOC has also listed some things that they consider not so reasonable. Generally speaking, eliminating an essential job function will never be a reasonable accommodation to provide. A person has been hired to do a specific task, and they need to be able to do it with or without an accommodation. So if they request that you take away one of their essential job functions, pretty much you can always say that that's not going to be reasonable. You don't have to lower production standards that is applied to all employees. Again, you want to be sure that everything is done across the board. And if you lower production standards for other employees, then you may need to consider this for as an accommodation request. You don't have to provide personal use items, as we mentioned before. And you don't have to excuse the violation of uniformly applied conduct rules. If someone violates an office rule that's, again, practiced across the board, then they're not protected by the ADA, even if they have a disability. So you don't have to excuse that, just as you wouldn't for anyone else. And you don't have to do anything that is considered an undue hardship. And that we will discuss in just a few minutes and give you some more information on that. Let's talk a little bit about service animals. We talked about service animals last month when Chris was your host. And so we want to talk about it again because it's a little confusing, especially when we're talking about now Title I. So let's talk about it a little bit. The definition of a service animal under the ADA for Title II, which is all programs and services of government agencies. That is, a service animal is any dog that's been individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability. The ADA also has provisions for miniature horses, so be prepared. One day you may see that. Under the ADA, a comfort, therapy, or emotional support animal does not qualify because they have not been trained to do work or perform a specific task. Service animals must be allowed in all areas where the public would be allowed. Public entities may only exclude service animals if the dog is out of control of the handler and the handler does not regain control, and if the service animal is not housebroken. But under Title I, everything is different. There's no definition for a service animal under Title I. So this means it can be really any type of an animal. It doesn't have to be trained. It's a case-by-case determination. And you may have some different animals. They may be a support animal, a therapy pet. And so be aware that the ADA under Title I, it may be something besides a dog, and you need to consider that just as you would any other accommodation. It may or may not be reasonable. The defenses that an employer has, basically there are two. If the individual has a direct threat or is a direct threat to the health and safety of himself, herself, or to others. You can only consider this if it's a significant risk of substantial harm, and the assessment must be strictly based on valid medical analysis and/or other objective evidence and not on speculation. It must apply to all applicants and employees and not just people with disabilities. And you should always consider an alternate accommodation that will eliminate or reduce that direct threat. So if they're a direct threat, an accommodation can be made and it needs to be considered. But if there's not an accommodation that can be made, that individual may not be hired or may be discharged. Another defense is undue hardship. Undue hardship basically means it's an action that requires significant difficulty or expense, unduly costly, extensive, substantial, disruptive, fundamentally alters the nature or the operation of the business. So you can see it's pretty detailed. All of this also is determined in relation to the size of the employer, the resources that are available, and the nature of the operation. So it will be determined on a case-by-case basis. And again, you always want to consider alternate formats that don't create an undue hardship. So if I ask for an accommodation that's been determined to be undue hardship, you still have an obligation then to look at some alternate accommodations. Enforcement of Title I is done by the Equal Employment Opportunity Commission. They have that responsibility, and a person who works for a Title II agency does not have to go through the Title II agency. They can directly contact the EEOC if they have a grievance based on disability. Some of the remedies include, as you can see, compensatory, punitive damages, back pay, front pay, benefits, attorney's fees, reasonable accommodation, reinstatement, and job offers. Some of the wonderful resources that you have available to you, you can see, hopefully you're aware of Job Accommodation Network, askjan.org. They are wonderful, and they answer more specific questions about reasonable accommodation. So you want to familiarize yourself with them if you're not already. The Equal Employment Opportunity Commission, they are the enforcing agency, but they also have many, many wonderful materials and information that you can look at on their website to help you with the different aspects of Title I. And then, of course, the Rocky Mountain ADA Center. We're here for you with questions. We can answer questions for you. You can also send in email questions. And then the ADA National Network, which is adata.org. These are all available to you, and so we hope you'll take advantage of that. Something I would like to mention to you, we are providing an ADA Coordinator mini-cap in Salt Lake City, September 20th through the 21st. We would love for you to participate. You can view more about that on our website. If you're interested in that, please do check it out. We have a monthly electronic newsletter that we'd love for you to sign up for. We also have a Facebook page, so we'd love to have you visit us there as well. I don't know if we have time for questions, but Jason, I'll send it back to you.
We will definitely take the time for questions.
Okay.
Still got lots of folks on there. Just before we dive into questions, though, that mini camp, so that so we obviously are just taking a really very shallow dive into this subject. That mini camp would really help prepare somebody to fall into that position and for their organization. Then, so it's looks like 2 days then, and
yes, and it's 2 days, very intense, and it basically works with the ADA coordinator to know that what their obligations, their responsibilities are in all aspects of the ADA. So it's not just employment, it's, again, all aspects of Title II and the ADA.
Great. Great. Okay, let's start off with some questions then. I had a question on the appropriate professional. Would a chiropractor or some other, or a holistic type physician or healer or whatever it may be, how far would somebody need to go when it comes to the appropriate professional?
Mm-hmm. In the two examples that you gave, like chiropractor, even the holistic, I would say yes, they probably would be considered an appropriate group, individual to provide that information, because they're going to know what the physical situation is of that particular individual. And of course, keeping in mind that an unsubstantial impairment isn't going to be covered. So this should be an individual who has a substantial disability, and the individual that provides that documentation should be a specialist. So I would say in general to err on the side of being broad. I would say yes, that they probably could be.
Okay, great. Curtis asked a question here. If an employee is injured while not at work and causes a disability, And as the employer, we have a return to work policy, including the doctor certifying that the employee can perform all job functions. If the doctor won't certify, must we allow them to return to work? So I think what I get from that, so the employer has a policy that says anybody who is injured off the job needs to bring in medical a doctor's statement that says that they can perform all job functions.
The fact that an injury occurs off the job doesn't affect the responsibility of the employer to provide accommodation. So it would be basically the same process that if an individual says, I need an accommodation, I have this major impairment, that you can request, again, documentation that the disability exists and that they need the accommodation. And then that goes back to them providing it. They have that obligation to do so, to provide the documentation. But it won't matter if it occurs on or off the job place. An individual with a disability is going to be protected by being able to request an accommodation.
Okay, along those same lines, can a workers' compensation injury become an ADA disability?
It can. It's always that obligation that an individual can request a reasonable accommodation. And so if a person is back at work and maybe not at 100%, they still can request an accommodation to perform the essential functions of their job. And so so in that case, it can. I know it can get really complicated when we're talking about workers' comp and anything, the ADA or anything else. But I would always have an open mind as to determining what the situation is, what the issue is. If the person can come back to work with an accommodation, the employer needs to consider that.
Okay. It looks like that's all the questions that I see coming in. Thank you once again for your time and your expertise in helping us with this kind of large and sometimes nebulous subject here. I appreciate the clarity that you've given us there. We actually have one more section of this webinar, and we'll be sending out an announcement for that here in the near future. So, final words.
If you have more questions, sometimes these little brief overviews bring up more questions than answers. Please feel free to give us a call at the 800-949-4232 number. We're here 9 to 4 with our phones. We also, you can text us or you can email us as well. And thank you for the opportunity to give this information. We look forward to working more with you.
Great. Thank you so much. I appreciate that. And we've got folks expressing their gratitude for the information as well. So thanks so much, Maggie. I appreciate that. We'll go ahead and wrap up the presentation.
All right.
All right. Maybe we will. There we go. Oh, let's see. One second. I've got to do this first.